Hello, everybody, and welcome to History/Law Bite number 282, dated June 27th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thanks for tuning in. This History/Law Bite is entitled Hylton versus United States, 3 U.S. 171, 1796. I think it's a pretty safe bet that you've probably never heard of this case. And even if you have heard of it, you probably don't know very much about it. And that's fine. Let's face it, this case was decided in the mid-1790s. It was, handed down during the U.S. Supreme Court's first decade of life. And in that era, the court was nothing like it is today. In the 1790s, the Supreme Court certainly did not command either the prestige or the respect that it does in the modern era. As a matter of fact, I bet you didn't know this, that in that period, it was very difficult to find individuals willing to serve on the Supreme Court, thanks to the very low pay and the treacherous requirement known as circuit riding, when the justices would have to literally ride out to different parts of the country to sit as trial judges on circuit duty in addition to their Supreme Court duties. Okay? So it was a very different era in American history, and we've certainly evolved a lot as both a country, all right, and a people in general, all right. And the Supreme Court certainly has evolved significantly as an institution since this case was decided, okay, nearly 230 years ago, all right. So Hylton versus United States, like I said, is arguably one of the Supreme Court's earliest decisions, okay? Being in the 1790s, the court didn't have a whole lot of work on its hands, so this case certainly was an individual one that had its own standout merits, which we'll get to soon enough. So let's begin the way all Supreme Court arguments begin. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. So let's get into Hylton versus United States. Now, this case, all right, essentially keeping it in its narrow sense, affirmed the constitutionality of a federal tax on carriages as an indirect tax, as opposed to a direct tax, which, according to the Constitution, had to be apportioned among the states according to their respective numbers. Okay? Direct taxes did not include taxes on the possession of goods, okay, which was what was at hand in Hylton versus United States. All right, that's what this court held with this case. All right, so the carriage tax was held to not be a direct tax. All right, so we see that our subject here is a federal tax on carriages. Not very exciting, is it? Indeed, it's not. But this is a very important case, and you'll soon see why. All right? So, to the facts. So, on the 6th of June, 1794, the Congress enacted a federal tax on carriages that were for the conveyance of persons kept for the use of the owner. All right? So, carriage designed for the transport of people, and a carriage that was specifically for the use of the owner. All right. In other words, they didn't lend the carriage out, for rent or other things like that. Okay. They kept it for their own private use. Okay. And Congress enacted this as a general tax, all right, or an indirect tax, not as a direct tax, okay? A direct tax, remember, had to be apportioned among the states according to their respective numbers, all right? This was an indirect tax, okay, which did not have to be apportioned in that way, okay? So, in May term of 1795, an action of debt, a debt action, all right, was initiated by the U.S. Attorney for the District of Virginia against our petitioner here, okay, Daniel Hylton, okay, to recover the penalty for not paying the duty on a number of carriages that were owned, okay, by Mr. Hylton, okay. The tax specifically was $16 on each carriage owned by an individual or business, okay, a carriage that was designed for the conveyance of persons and kept for the use of the owner. Now, $16 might not sound like a lot, but in the context of 1795, that was a whole lot of money, all right? So, you know, he probably felt this was kind of unfair. $16 is a lot of bucks. So, in court, Mr. Hylton pleaded nil debet, which is an old expression meaning he owes nothing, all right, contesting the owed tax. So the right to a jury trial was waived, and the case accordingly was submitted to the Circuit Court for the District of Virginia, all right. The case against Mr. Hylton asserted that he kept and owned 125 chariots or coaches for his private use, not to be lent out to others. He refused to make entry of these chariots or pay the duties imposed, arguing that it was a direct tax and it was not apportioned properly, and therefore it was unconstitutional and void in direct violation of Article 1, Section 9, Clause 4 of the Constitution, as well as Article 1, Section 2, Clause 3 of the Constitution. Okay? United States, of course, argued the opposite, that it was an indirect tax and did not have to be apportioned according to state populations. All right? So, needless to say, judgment was entered against Mr. Hylton in the Circuit Court for the District of Virginia. So at the Supreme Court of the United States, the justices were faced with a very simple issue. Was the tax on carriages a direct tax which would require apportionment among the several states according to population? The opinion of the court, 4-0 for the United States, held that this tax on carriages was an indirect tax and not a direct tax requiring apportionment among the states based on population. I'd like to add one more thing, that in this era, there was typically no opinion of the court per se. In the 1790s, the justices practiced the Old English style of seriatim opinion writing, where each justice wrote something down and delivered their opinions accordingly. All right. And obviously, whichever side the majority of justices leaned towards was obviously the side that prevailed in the case. All right. But there was no opinion of the court by justice such and such as we're used to today. OK, so it was a seriatim opinion given. Seriatim opinions were given here by justices Patterson, Erdell, and Wilson. Justice Samuel Chase was also in the majority, but he did not write, okay? So it was a 4-0 opinion for the United States, okay? Chief Justice Oliver Ellsworth and Justice William Cushing did not participate in the decision here, okay? So I'm just going to read a few excerpts from the opinions of Justices Patterson and Erdell. Patterson wrote, consumable commodities, whether necessities or luxuries, may be taxed in two different ways. The consumer may either pay an annual sum on account of his using or consuming goods of a certain kind, or the goods may be taxed while they remain in the hands of the dealer and before they are delivered to the consumer. The consumable goods, which last a considerable time before they are consumed altogether, are most properly taxed in the one way. Those of which the consumption is immediate or more speedy in the other. Okay? The coach tax and plate tax are examples of the former method of imposing. The greater part of the other duties of excise and customs, the latter. Okay? So from Justice Erdell, we see the Congress possesses the power of taxing all taxable objects without limitation, with the particular exception of a duty on exports. There are two restrictions only on the exercise of this authority. Number one, all direct taxes must be apportioned. Number two, all duties, imposts, and excises must be uniform. If the carriage tax be a direct tax within the meaning of the Constitution, it must be apportioned. If it be a duty, impost, or excise within the meaning of the Constitution, it must be uniform throughout the country. Can't be higher here than it is there, okay? If it can be considered as a tax, neither direct within the meaning of the Constitution nor comprehended within the term duty, impost, or excise, there is no provision in the Constitution one way or another. And then it must be left to such an operation of the power as if the authority to lay taxes had been given generally in all instances, without saying whether they should be apportioned or uniform. And in that case, I should presume the tax ought to be uniform, because the present Constitution was particularly intended to affect individuals and not states, except in particular cases specified. And this is the leading distinction between the Articles of Confederation and the present Constitution. As all direct taxes must be apportioned, it is evident that the Constitution contemplated none as direct, but such as could be apportioned. If this cannot be apportioned, it is therefore not a direct tax in the sense of the Constitution. That this tax cannot be apportioned is evident. Okay? So the court, all four justices who participated, found that this tax on carriages was an indirect tax, therefore subject, of course, to uniformity, but not to be apportioned among the states according to their populations, as it would be required by the Constitution if it were a direct tax. Okay? So the tax was ruled to be constitutional as it was, okay? Fully in compliance with the Constitution, all right? It was not in violation in any way of Article 1, Section 2, Clause 3, or Article 1, Section 9, Clause 4 of the Constitution, all right? The tax on carriages survived the constitutional challenge. Hope you're following along and paying attention so far, all right? So the judgment of the Supreme Court affirmed the judgment of the Circuit Court for the District of Virginia, okay? And once again, the federal tax on carriages was affirmed as constitutional, as it was an indirect tax and not a direct tax, which would have to be apportioned among the states accordingly as required by Article 1, Section 2, Clause 3 of the Constitution and Article 1, Section 9, Clause 4 of the Constitution. The federal tax on carriages, as written, was constitutional and as applied as well. Okay? So, some interesting facts about this case. Alexander Hamilton, America's first Treasury Secretary, all right, and founding father, very important founding father in many other ways, argued this case on behalf of the United States. In spite of his not so great health at that point, he argued for 3 hours and very passionately and in a very compelling manner, quite obviously because he won the case for the United States. All right? In addition to that, This was a very observed case, okay? Justice James Erdell noted that while this case was being argued, he saw more people, in attendance to hear it than ever before at a Supreme Court argument session, all right? Many members of Congress attended this argument, all right? So all eyes were on the Supreme Court. Justice James Wilson, all right, remember I mentioned that circuit duty thing at the very beginning. Justices had to also serve as trial judges in addition to their Supreme Court duties. Well, Justice James Wilson, all right, was the circuit justice who covered, this area in which Virginia was included at this time. And he was the trial judge who heard the case on circuit duty in Virginia, all right, and is the one who passed the original judgment against Mr. Hylton here before the case would ultimately go to the Supreme Court. And you'll find that a lot back then, that during the days of circuit duty, quite a few of, not most, if not all of these cases that the Supreme Court heard during this earlier period in American history had already been heard by one of the members of the court sitting as a trial judge on circuit before it actually got to the court. And of course, given the, conflict of interest rules at the time, this didn't require the justice who had already heard the case on circuit to recuse themselves from hearing it on appeal. So that was a different time. Needless to say, in these times, you certainly would need to take yourself off of the case because you've already heard it. And last but not least, if you have not been paying attention and you heard me mention the word constitutionality here, let's get back to basics. This case presented the very first time in American history where the Supreme Court exercised its power of judicial review, folks, which is the power of courts to determine the constitutionality of laws and executive actions, all right? As well as legislative actions, too, outside of lawmaking, all right? Now, if you recall, Marbury versus Madison, which was decided 7 years after this case in 1803, is often given the credit as being the first time the court utilized judicial review. But that's not true, okay? Marbury versus Madison is only half correct in that regard. In Marbury, the court for the first time held part of an act of Congress, the Judiciary Act of 1789, to be unconstitutional. That was the first time that the Supreme Court utilized judicial review to declare part of a federal law unconstitutional. But it was not the first time that the Supreme Court used judicial review per se. The first time they used judicial review per se was in this case, Hylton versus United States in 1796, 7 years before Marbury. However, in this case, as we have seen, with the opinions of the court per se, the court affirmed the federal law in question as constitutional. So there was no need for the court to invalidate any part of the federal law taxing carriages, okay? The court affirmed the federal law as being fully constitutional, whereas in Marbury, the court invalidated part of a federal law it found to be unconstitutional, okay? So that is the significance, ladies and gentlemen, of Hylton versus United States. It is the very first case in which the Supreme Court utilized its power of judicial review. Here, however, it affirmed the constitutionality of a federal law in question, whereas in Marbury, 7 years afterwards, in 1803, it struck down part of a federal law it viewed to be in conflict with the U.S. Constitution. Okay? So that is Hylton versus United States, all right? Decided in 1796, and leaving us with the basic holding that the federal tax on carriages here was constitutional, and that direct taxes did not include taxes on the possession of goods. All right, as this was a tax on the possession of carriages for private use. All right, this was an indirect tax and therefore not a direct tax. Okay, and therefore this law did not violate Article 1, Section 2, Clause 3 of the Constitution or Article 1, Section 9, Clause 4 of the Constitution. Direct taxes did not include taxes on the possession of goods. All right. This law in question was not a direct tax. It was an indirect tax and was therefore constitutional as written and enforced among the people. All right. So if you have any questions or controversies, leave them down below and I'll be happy to answer them. If you learned a thing or two from this video, drop me a like. That would be exceptionally appreciated. And last but not least, if you've not subscribed to my YouTube channel, I would appreciate that more than you will ever know. I mean, we're all trying to grow and expand here, and it brings me a great deal of pleasure to teach you these things. All right? So I want you to take care of yourselves, stay safe out there, and I'll talk to you at the next bite. Peace.